Good morning or good afternoon, everyone. Thank you for joining us for today's Leaders in Law session. This is our second season of this series of webinars. My name is Erin Page, and I'm the Senior Law Librarian on staff with Fast Case Legal Research. And it is a pleasure to have everyone joining us today. We have a couple of fantastic speakers lined up, so I encourage everyone to check their emails for future sessions that are coming for Leaders in Law. I will introduce today's speakers in just a moment, but before I do, just a couple of quick housekeeping announcements. The first announcement, you may have noticed that you are currently in listen-only mode. This is to ensure that there's less background noise so that everyone can hear us during the presentation. However, questions are welcome during today's session. To ask questions, on your screen, you should still have the GoToWebinar pop-up, and there is a button on that pop-up for questions. Enter your question, and I will make sure that they get interjected into the flow of the conversation, as it were. If we do not manage to answer your questions during the session, we will also have time for follow-up after today's session. Our second announcement, today's session is not for CLE credit. It is a fantastic session. There's going to be a lot of great information, but it is not for CLE credit. However, FastCase does offer CLE accredited webinars. The information for those webinars is on our website, fastcase.com/webinars. All right. So with that as our housekeeping out of the way, I'd like to introduce today's speakers. Excuse me. Our first speaker is Judge Cannon. Judge Cannon is a fantastic speaker, very knowledgeable on the history and underpinnings of the death penalty. He will be kicking off today's session. We also have with us today Ngozi Ndulue, who is from the Death Penalty Information Center. She's also going to be speaking to today's modern impact and effects of the death penalty. And we have a large number of materials that are a part of the slides for today's presentation. Those packet of information will also be sent to you as registrants for today's session via email after today's presentation. So with that, let's go ahead and get started.
Thank you, Erin. It's a pleasure to be here and being on this panel with Ngozi. Our friend Henderson Hill may also join us at some point during the session. The program is titled The Death Penalty Past, Present, and Future. I have the somewhat unenviable task of representing the past, and then Ngozi will be bringing us up to date. So let me just talk about the nutshell history of the death penalty. I'm sorry, is this all right? The death penalty came over in colonial times. Obviously, the death penalty was very much in use in England in the 1600s. And the first person to have been recorded to be executed was in 1608, a George Kendall for spying for Spain in Jamestown. The first woman to be executed was in about 1640s for killing a child. Estimates and researchers have said that of the so-called legal executions in the United States from colonial times to roughly the 1990s was over 15,000. Notably, this 15,000 does not include, obviously, a sad part of our history, a tragic part of our history, that is slavery and lynchings. And you can't think about the death penalty without obviously accounting for what had happened in our history. The Equal Justice Initiative in Alabama has done a great deal of research and found about 4,000 Blacks were lynched from 1877 to around 1950. Another researcher had similar numbers and also had about 1,300 whites were lynched as well. The U.S. Constitution got, after the American Revolution and after the colonialists were writing their Constitution, assumed that the death penalty was part of the legal fabric of society. Indeed, in a number of sections in the Constitution itself, specifically in the Fifth Amendment to the Constitution, assumed that the death penalty was part of our Constitution. On 3 separate sections, no person shall be held to answer for a capital crime unless presented by an indictment by a grand jury. The second part deals with double jeopardy, nor shall any person be subject to the same offense to be twice put in jeopardy for life or limb. And then finally, the due process clause, that persons could not be deprived of life, liberty, or property without due process of law. The Eighth Amendment, and it's this tension between the Fifth Amendment and the Eighth Amendment that really has summed up death penalty litigation over many years, says that prohibits cruel and unusual punishments inflicted. And what that means has been debated over the years, with one thought being that just dealt with torture and purposeful infliction of pain and punishment. The death penalty was in some ways petering out in the 1960s. There were no executions in 1965 through 1972. And the issue got teed up in the Supreme Court case of Furman versus Gregg, where the constitutionality of the death penalty was squarely before the court. In a 5-4 decision with a number of different concurring opinions, so there was not one unifying opinion for the court. A number of justices, Brennan and Marshall, found that the death penalty under all circumstances was per se constitutional. Justice Douglas found it was discriminatory and therefore unconstitutional. And I'm just giving the nutshell version of it here, just for time purposes. But what became the narrowest decision was the decisions of Justice White and Justice Stewart, who found that the death penalty as applied was arbitrary and capricious in its form and its execution, and therefore unconstitutional. The dissenting justices essentially argued that under the Fifth Amendment, it was clear that the founders understood the death penalty to be constitutional. And I should also add, when the 14th Amendment was adopted post-Civil War in the Reconstruction era, it also engrafted the life, liberty could not be deprived without due process of law, applying the Fifth Amendment to the states as well. So, and they also believed, and again, I'm just summarizing briefly, that this type of decision was more for the legislature than for the courts to handle. With the finding that the death penalty was unconstitutional in 1972, it was scholars at the time thought that that was the end of the death penalty. But the states then reconfigured and passed new death penalty statutes, what we call the guided discretion statutes, that would allow for the execution of an individual after a 2-part trial, the traditional guilt-innocence trial, followed by a sentencing trial before the same jury. And this jury would be guided in its decision-making by the requirement of finding various aggravating factors, such as the victim was a child or a senior citizen or a law enforcement officer, things of those nature. And the jury would have to balance or weigh the aggravating factors versus mitigating factors. And mitigating factors could be the lack of a criminal record for the defendant, a difficult childhood, mental illness, and any other things that trial lawyers could put before a jury. So it was this balancing of aggravating versus mitigating circumstances that formed the guided discretion schemes that were approved. Notably, a number of states responded to the 1972 decision in Furman by having mandatory death penalty. So it wouldn't be arbitrary or capricious. Everyone who fit a particular profile, that is the nature of the crime itself, if it was the killing of a child, a senior citizen, a second homicide, that type of thing, would receive the death penalty. Notably, the Supreme Court, employing a part of its jurisprudence that death is different, required an individual decision-making for each case and found the mandatory sentences unconstitutional. Now, over time, the Supreme Court, invoking the Eighth Amendment, has found various other aspects of the application of the death penalty unconstitutional. The standard is basically whether or not the crime or what's going on doesn't match the evolving standards of decency that mark a maturing society. And what that really means, of course, is a philosophical thing, a legal philosophical, and depending on how you view the Constitution. But over time, since post-Furman, the Supreme Court has held as unconstitutional the death penalty for juveniles, those who are intellectually disabled, rape of an adult woman followed by rape of a child, what's called the Non-Triggerman. It used to be under the felony murder doctrine, well, still is under the felony murder doctrine in most states. One could be found guilty of first-degree murder by being the getaway driver or someone who aided and abetted in the commission of a crime. And the Supreme Court has now felt that it has to be the person who actually committed the homicide that would be eligible for the death penalty. So it has been whittled down over the years, and there may be some others that I'm neglecting. I'll tell you my experience as a death penalty lawyer. Really, it happened in the 80s when myself and Steve Bright and George Kendall, we answered an invitation to go to a local church in Washington, D.C. to hear a speaker, a death penalty lawyer named Millard Farmer, come talk about what was going on in the death penalty post-Furman in the late 70s, early 80s. And what we knew then, and it was emphasized by Millard, who sadly passed away several years ago, and he really was the dean of death penalty lawyers that many of us looked up to. Under the law, as it stood then, and still now actually, criminal defendants by the Constitution are entitled to a state paid for lawyer at their trial and at their direct appeal. They're not entitled to a state-funded lawyer past that. It includes writs of certiorari or this complicated writs of habeas corpus in the state courts and in the federal courts. And so in many states, once the defendant was past his direct appeal, there was no lawyers to be had. And as a result, the ACLU of Georgia, just to give an example, with Patsy Morris, the late Patsy Morris, and Millard and others, were recruiting lawyers from all over the country. Many were recruited from Washington, D.C. And Steve Bright and George Kendall and I were recruited at that very speech to handle a writ of certiorari for a young man who I'll call Donnie, and to do his writ of certiorari. Now, we were young lawyers back then and were probably pretty foolish, but we weren't stupid. And we kind of knew that this invitation to just do the writ of certiorari also included, if that writ of certiorari was denied, is to go on and represent Donnie in cases in habeas corpus in both the state courts and in the federal courts. And we waited anxiously for the record to be sent to us. And we were, I suppose, shouldn't have been surprised, but we were surprised when the record finally came, and it was about this big. And the trial took place in the morning, starting at 9 o'clock. He was convicted of first-degree murder by 5 o'clock. Everyone took a break for dinner, and then he was sentenced to death by 9 p.m. So he was convicted and sentenced to death in one day. And quite frankly, in Washington, D.C., some misdemeanor cases get far more attention than this death penalty case. And so we should not have been surprised, but we were. This was our first case. And so we took that case. And then several years later, Steve was invited to help form the present day, what's now the present day Southern Center for Human Rights. And I went along with him to Atlanta. Bob Moran, one of our friends, and later, like me, a judge on the Superior Court, later our chief judge, also came down, and a lawyer named Christy Freeman, who's still fighting the fight in Alabama as the federal defender, I believe. So the four of us were the then called the Southern Center for, then the Southern Prisoners Defense Committee, now the Southern Center for Human Rights. And we were basically doing legal triage at the day, because Alabama would set an execution date, or Florida would set an execution date. South Carolina would set an execution date, and there were no lawyers to handle those cases and no real organizations other than us in the South to do that. And so we were rushing from state to state really to try to get stays of execution to litigate these cases further in habeas corpus. So it was, I must say, some of the most exciting and exhilarating and rewarding work that we've ever done, because we were successful in any number of cases in getting people off death row and stopping executions. It was also some of the most tragic and difficult to accept even now, since we did lose clients in terms of being executions in Alabama and Florida, South Carolina, and Georgia. So, and most of us stayed in the death penalty field for any number of years. And then I was fortunate to be appointed to the court, to the Superior Court in DC in 1993. And I've taught a class on the death penalty in various law schools, but have not been an active practitioner. So hence I am representing the past of the death penalty in this country. I should also add that we're one of 4 democracies, Japan, Taiwan, and Singapore, that still has the death penalty. And we stand next to China, Iraq, Iran, Saudi Arabia, and Egypt is actively imposing the death penalty. So I'm going to turn this over to Ngozi, who is far more knowledgeable than I am now in the present application of the death penalty and the future. And there's much to talk about the future. So I'm going to turn it over to you, Ngozi.
Thank you. And with your indulgence, I'll start a little bit in the past myself. So Aaron, if you could advance the slides a little bit, that would be great. And we can get to the first one with enduring injustice. There you go. Thanks so much. So I always kind of want to remain rooted in that path that Judge Cannon has given us as a beginning and an overview. And one of the things I always want to highlight is the role of race from the very beginnings of the United States death penalty till today. And in fall of last year, we released a report, Enduring Injustice, the Persistence of Racial Discrimination in the U.S. Death Penalty. It's 88 pages, there's a lot there. But what we talk about there is about the existence of kind of racial discrimination in the United States death penalty from the colonial times. Like in colonial times, there were different capital crimes depending on your race and the race of your victim, particularly in the South and states with slaves. We saw specific different punishments. And there were many more capital crimes for Black people. Sometimes you'd have different ones for free Black people compared to enslaved Black people. But even in the North, you saw different use of capital punishment, where you would see kind of more gruesome or torturous executions based upon race. You would also see, compared to the amount, the percentage of the population that was Black, you would see a higher amount of capital punishment being used against the Black population. There was definitely the use of capital punishment to kind of send a message for social control is deeply rooted in the history of our country. So I always want to kind of begin with that history and trace capital punishment and its use to today, where we see some of similarities there, and also that connection that Judge Cannon touched on a little bit, but that connection between so much of extra legal, extrajudicial violence that we would assume was just mob violence, lynchings, and racial terror, and the official capital punishment system. We know that those kind of extra legal violence based on race and the legal capital punishment system have also always been intertwined. We see that most starkly when we think about the lynching era, where in the late 19th century and the early 20th century, there were rising rates of kind of racial violence, and what the Equal Justice Initiative, which has done a lot of work on publicizing our history around lynchings, talks about as kind of racial terror lynchings. At that time, there were discussions about, whether to keep capital punishment or not, and there was a concern that if you got rid of capital punishment, you'd have more lynchings. And there were times when, lynch mobs that we see as kind of unorganized, but actually often had official sanction, the kind of leaders of communities would say, no, don't lynch the person. We'll get them through the criminal justice system. We'll have a speedy execution. We can promise you that. So given that, we know that these two things are very tied. And I also want to emphasize that this is a system that when we think about race and the capital punishment system, we often think about African Americans, and there was a specific tie-in between, slavery, Jim Crow, the use of the entire criminal legal system to kind of continue that racial stratification, and the use of the capital punishment in the past. But there are also, we can think about mob violence against Mexican Americans in the Southwest, and how that was also very intertwined with the use of legal executions there. We also can think about the conflicts between Native American sovereignty and the capital punishment system throughout history, even up to present day, that have kind of shown themselves throughout the process. Frankly, one of the places that we see the use of capital punishment is with someone who's being considered the other, or someone who's being considered in a group that is kind of seen as socially undesirable. And we have, examples throughout history where those people in those groups have been shown to be kind of more vulnerable historically to the both extra-legal violence and in the capital punishment system. So I just wanted to highlight some of those themes that are in this report that kind of help us to both understand the history and to contextualize the present. Because when we think about the present in the use of the death penalty, we can talk about this modern era, the post-Furman era. And when we look at the use of the death penalty in the post-Furman era, we realize that much has changed. There were concerns about arbitrariness and about discrimination, and the kind of reply to those concerns was adding layers of procedure, adding excluding certain groups from the death penalty, as Judge talked about with juveniles, people with an intellectual disability, where we see those groups being excluded from the death penalty for those Eighth Amendment concerns. But we still see that while much changes, much remains the same. So Erin, if you could go to our next slide. Oops, Erin, thank you. We know that the role of race in the capital punishment system today remains very strong. When we think about who's on death row, we know that the percentage of people of color on death row is much higher than the percentage in the general population. And when you say that, there could be a question, well, what about kind of the rates of offending, the rates at which people commit murders? And you can see higher rates of people being prosecuted for homicide based on race. But then let's look at the race of victims. We know that most crime that's committed is intra-racial, right? So Black people would be killing Black people, white people would be killing white people. But we see that who is actually being sentenced to death for the crimes against whom is very much affected by race. So if a person has committed a crime and the victim, homicide, victim is white, we know that the crime is much more likely to be solved in the first place, that there's actually going to be an arrest. We also know that among the people, and there have been studies in various jurisdictions, and the vast majority of studies show that if you have a white homicide victim, you're much more likely to receive a death sentence in the first place. And then if we talk about who is being executed, you're much more likely to be executed. And this chart on the left is about race of the defendant among all those who have been executed. There have been more than 1,500 executions in this modern era of the death penalty. And when you look at the race of victim, that's where you find really stark compared to the race of victims overall of homicide. So about half of homicide victims over this time period were white, but about 75% of the victims in cases that end in an execution were white. So we know that who has been killed makes a really big difference in how the death penalty is being applied. Another really striking figure here is when we look at interracial crimes. So when we look at those 75% of murder victims among the category of people in cases that resulted in executions, they're, like I said, most, crime in general and homicide in particular is intraracial. So a lot of those white cases with white murder victims had white defendants. But if we look at a different category, when we're looking at cases with white and so we're not talking about other people of color, we're specifically talking about African American and white people, where these are interracial crimes involving African American white people. We see that over the entire modern history of the death penalty, we've only had around 21. We might have one or two more since the publication of this report, but around 21 cases where the defendant was white and the victim was Black. And there are several states, I think 8 last time I counted, where there's never been a white person executed for the murder of a Black victim. And then here we have, on the other side, where there's a Black defendant and a white victim, we have about 290 cases, more than 290 cases where that has happened. So there's a real asymmetry here, and this is also kind of talking about the way that our death penalty is being used and how central race is to the actual application of the death penalty today. So that brings us to the present, but when we're thinking about kind of the recent years and the past few decades, I think it's important to kind of look at the trends and how this has been connected to the way that we're thinking about crime, the way that we're thinking about public safety, and what we're seeing it as most useful and important when we're actually trying to create safer communities. So Erin, if you could go to the next slide. So this is a chart of death sentences in the modern era. So after Furman was decided, states passed new laws so that they can pursue the death penalty. And so these are all the death sentences under those new laws. And what we see is that, there was a real rise in death sentencing up till the late 90s. And if we think about that, we can put that into context of the conversations that we're having about our criminal legal system, where there was this whole tough on crime era. We've talked about this a lot in just kind of national conversations about the criminal legal system, but the idea of these juvenile super predators, the response to, the war on drugs, there was just a general atmosphere that, the tougher, the better, that prosecutors would run with this idea that look at how many death sentences have been imposed on my watch. And we've seen a real change in the way that the death penalty is being used and how people have been approaching it. So since that time, we've really seen a pretty sustained decline, where at one point at the peak of death sentencing, in that height of our tough on crime era, we had more than 300 new death sentences in some years. And now we're at a place where, every year we have less than 50 death sentences. And that's, before we had, the coronavirus, which really disrupted court, proceedings, where we're seeing basically a change in the ideas about whether the death penalty is actually contributing to public safety. We're also seeing an understanding of the costs of the death penalty. Oftentimes, people don't realize how much more expensive the death sentences, pursuing a death sentence is, compared to other alternatives. And Erin, you can go to the next slide too. And when we talk about executions, which happen years after the initial death sentences, we see a mirroring of the same trend. Now, obviously, these executions are happening for folks who've been sentenced to death 10, 20, sometimes 30 years before. But what we see is a real sustained reduction in the use of executions as well. So during that time, again, where we saw the tough on crime policies as the focus, we saw more than almost 100 death sentences or executions at its peak, and we have been under 30 death sentences for the last 5 years or so. We also see the same as far as shifts in states' practices around the death penalty. First of all, even in states that have the death penalty, there are many that have not had an execution in the last 5 years and the last 10 years. And we're seeing a steady erosion of states even authorizing the death penalty. This year, Virginia abolished the death penalty in large part based on racial justice concerns. But this was also a state that over time has had the most executions, not in the modern era. Modern era is Texas. But if we go all the way back to colonial time, the first execution and the most executions happened in Virginia. But by the time we got to, abolition, there hadn't been a new death sentence in years. There were just, I think, 1-2 people actually on Virginia's death row at the time. So we're seeing a shift in perception, and some of the reasons for that shift are because of our questions. First of all, we know that there are no reliable studies to show that the death penalty deters crime. We also know that the death penalty costs more. And one of the reasons that it costs more is that because there's supposed to be additional process that is supposed to be kind of ensuring that when this life or death decision is being made, when we're thinking about executions, that the wrong person is not executed, somebody who didn't commit the crime or shouldn't be eligible for the death sentence. However, we know that despite all of these kind of procedural protections, we still have people wrongfully convicted. We have 185 people who have been exonerated after having a death sentence. And the knowledge of that, and the knowledge that the fact that innocent people do get convicted despite having more lawyers and supposedly more support in the death penalty cases, that innocent people go through the entire proceeding, all their appeals, and are still on death row. And that sometimes it's the coincidence of having a particularly interested reporter or a great intern at the Innocence Project, or some of the wonderful lawyers at the Innocence Project, who are able to actually get somebody who has gone through the entire legal process and is finally recognized to have been wrongfully convicted. I'll also put a pin to note that race matters there too, because we also know that the majority of people who have been exonerated are people of color, and that people of color take longer on average, 4 years longer on average, to be exonerated. So again, the idea, the role of racial discrimination is really just throughout every step of the capital punishment system. But this knowledge about kind of mistakes can be made. There are some really strong examples of people who have been executed, who we think were innocent. Cameron Todd Willingham in Texas is a great example. He was convicted of setting a fire that killed his entire family. There was junk science that was presented that showed that the fire was an arson, but modern techniques are pretty convincing that it was an accidental fire. So imagining the fact of somebody who was executed for killing his family when they died in an accidental fire is really shocking to many people to think about, and why many people have rethought their support of the death penalty. We know that when asked, people would prefer a life sentence to, the majority of people would prefer a life sentence to death penalty. We still have support. If you just ask people, is the death penalty okay? We still have support of that, but it's at its lowest. The support is at its lowest in decades right now. So I think we're seeing a shift in the way that the death penalty is viewed. What that means for the future, we have seen about a state a year for the last few years, abolishing the death penalty either legislatively or like in Washington State, where the state Supreme Court said because of its arbitrary and discriminatory application, the death penalty was unconstitutional under their state constitution. Given the Supreme Court and its kind of its recent rulings around the death penalty, it seems that the United States Supreme Court has not been receptive to claims about, a variety of claims about the death penalty. We've seen that because the federal government, for the first time in many years, conducted a number, kind of a historically, exceptional streak of executions in 2020 and finishing up in 2021. But at this moment, we also see that the current administration not supporting the death penalty and kind of vowing to work to end it. So there definitely seems to be one kind of attrition in the use of the death penalty, even when the death penalty is actually on the books. We see states that are taking the death penalty off on the books, but we also continue to see kind of outliers. So the federal government was an outlier last year where they just kind of had this kind of slew of executions. So one of the things we know is that the use of the death penalty has been very concentrated. Less than 2% of the counties were responsible for more than half of the people on death row. And the same thing, that less than 2% of the counties have been responsible for more than half of the executions. So what we see is the use of the death penalty becoming more and more concentrated in a smaller and smaller geographical area with these kind of outlier jurisdictions. But we also see that changing in that in some of those jurisdictions where the heaviest use of the death penalty was happening, we see prosecutors who have a real outsized role in whether the death penalty is being used and how frequently it's being used. We see prosecutors who have been running on platforms of either not using the death penalty at all or using it sparingly. So that's a shift too, especially when you had prosecutors who had advertisement. I can think of Cowboy Bob Macy in Oklahoma who had like a newspaper ad touting the number of people he sent to death row. That type of kind of politics, that type of behavior has become, definitely not the norm and very much outside the norm now. So I think we're seeing kind of some enduring shifts in the way that the death penalty is seen and used. and we'll see as far as where this kind of slow attrition leads us in the future.
Excellent. Well, we have a couple of questions from the audience that I think now would be a great time to address. And the first question is for both of our speakers. When you're looking at such statistics and such numbers as have been used in this presentation, how would you recommend using such statistics? How would you use them to show such a disparate impact in the courts today? Judge Cannon, when you were on the bench, did such statistics impact your decision-making process? Did you take them into account as part of your decision-making on the bench as well?
Well, the District of Columbia, where I sit, doesn't have a death penalty, so I was never faced with these kinds of issues. And clearly in the law, data and the presentation of data has had an outsized influence, and rightly so, on many decisions. So I think there's clearly a place for it. And I think, in Virginia is a good example where the governor and some of the leading legislators, when they gave their reasons for abolishing the death penalty, they were very influenced by some of the data that Ngozi was mentioning here today. So yes, it has a substantial play in both the courts and in the legislators.
And I'll also say that there have been some specific state initiatives about using those statistics. So one of them is Racial Justice Act. So Kentucky has one which is not very effective. I don't think there's been. I think it's very limited. But North Carolina passed the Racial Justice Act, which really kind of provided an avenue for using these statistics about race to actually support a claim in the courts. We know that at the United States Supreme Court, because of McCluskey, the court said McCluskey versus Kemp, statistics are not enough. You have to show this purposeful discrimination. But in North Carolina passed the Racial Discrimination or Racial Justice Act that said, yes, you can use statistics along with other evidence of discrimination. Given that ability, a number of capitally sentenced defendants were able to show the role that race played in their cases, and including the statistics and including things that actually, other factors. We see that they were successful, too successful, because a new legislature first limited and then repealed the act. However, a recent decision this summer said you can't, for the people who had pending cases or pending claims at the time, you can't just, take that away. So the pending claims got reinstated. Some people actually ended up with non-death sentences because of that. So I think that is one place where we've seen statistics mattering. Another one, California just this year passed the Racial Justice Act. They also passed a law that revised the way we think about peremptory strikes. Another part that race plays in capital cases is when peremptory strikes are being used to exclude people of color from juries. We know that Batson versus Kentucky provides an avenue to challenge that, but we know that it's often an ineffective challenge, that many really excuses can be given for striking jurors of color, and they've been accepted widely. And even there was a recent case where the prosecution had noted every single Black juror, and the court accepted, well, what they were doing was to make sure that they were not seen as discriminatory, even though they struck all of those folks. That was what they were doing. It wasn't that they were, noting the race of the jurors so that they remembered who to strike. So we know that Batson has been ineffective, but California passed a law that allowed the use of discussion of implicit bias and ways that implicit bias can affect peremptory strikes, and also just a broader a better presumption that would allow challenges to juror strikes to hopefully be more successful than under the Batson framework. Another thing that I would say, and I'll also just mention that this is a particular issue in death penalty cases, because in death penalty cases, jurors have to be death qualified, which means that they don't have a very significant barrier to considering the possibility of a death sentence. There's better legal language around that. And so by death qualification, it already excludes a lot of jurors of color because there's less acceptance of the death penalty among jurors of color, but also it provides an avenue for strikes for cause and more questioning that can be used to target jurors of color and kind of what a California report talked about, whitewashing the jury. So I would say that there are, in specific states, statistics have been used and have been given more ability to be used for challenges. I think that there are also ways that litigators have creatively used the statistics around race to challenge a variety of issues and in some kind of pretrial motions as well. I think if folks look at our Enduring Injustice report, we talk about all the different areas about race, about a Philadelphia study that showed in interracial crimes where there was a Black defendant, white victim, that the Black defendant that was darker skinned or had kinkier hair, wider nose, was more likely to get the death sentence. So I think that there are a variety of kind of studies and statistics that are useful and important to provide a context for courts, legislatures, and the public to really take a critical eye and have be better informed about capital punishment.
Excellent. We have a further question about the statistics as well. Specifically, the audience would like to know, have the racial disparities regarding white victims reduced at all over the years? Knowing that some of these statistics have been available for longer, has that had any impact on that disparity over time, or do you still see the same proportion or the same disparities over the years?
I mean, I think it has been roughly around the same. I think at some points it might have been more like 80%, but it's been between the kind of 75 to 80%. So I don't think that there has been a huge shift. I think one thing to point out about that race and victim. So I think if we go back to the original study for McCluskey versus Kemp, this is a study of Georgia death sentences, and it was focused on your likelihood of getting the death sentence when you have a white victim. And we've seen, there are studies that show that if the defendant is African-American, they're more likely to get sentenced to death, but that hasn't been held true in every single jurisdiction that's been studied. The most persistent result is race of victim matters, and it's going to affect who gets the death sentence. So researchers just, it was 2 years ago, I think, that they did the research, but I think it got published this summer. I don't have the names off the top, but you can look in our study. Our report, we mention it. They looked back at those people who were in the Georgia study that McCluskey versus Kemp was focused on. So at the time of the Georgia study, they showed that the odds of getting a death sentence were 4.3 times higher if the victim was Black or victim was white. And so the researchers followed these defendants through the process. And so they looked at, okay, so from the beginning where the McCluskey researchers were starting, David Baldus, to execution, because if you think about, the McCluskey was 1987, the vast majority of the people who were in that study either were off of death row, resentenced to a sentence of life or less, maybe they were exonerated, or they were executed. So basically their cases are done for purposes of that. And they found that when you looked at execution, you saw an even wider gap. Like you saw that race of victim predicting who would get executed. I think it was 17 times. The rate of execution for people with white victims was about 17 times higher if you had a white victim, right? So this idea that we have race effects at the very beginning, from the very beginning, about whether you close a homicide case to the very end execution, and they are kind of compounding on each other from stage to stage to stage. We can talk about all the reasons why. So I think it's crystal clear and hard to debate, that the race of victim matters about, and why it ends up in determining who ends up getting a death sentence, who ends up getting executed. Whether people have been willing to address that is a different question. And I think the answer is, frankly, not consistently. So the Supreme Court has said statistics, U.S. Supreme Court has said, not all state Supreme Courts have said that. Without, there have been specific states that have made different choices, that have said either we're going to try to take some type of remedial action through Racial Justice Act, or we're going to get rid of the death penalty altogether, because we've never seen it imposed in a way that is actually non-discriminatory, and we don't think it's going to be.
Excellent. Well, speaking of the report that came out this summer, one of the things that you provided for today's session was some really great resources for further review by attendees and registrants. I'm going to go ahead and pop them on the screen. As I mentioned, everyone will be receiving the slides from today's event as part of their follow-up from today's event. But is there a particular resource or a particular link that's a part of these resources that you would recommend for someone who is looking for more information regarding these studies or regarding their impact on trials?
I would say all of them. So I included in these resources a lot of things from the Death Penalty Information Center's website, and from the very basics of a fact sheet where you can learn more about, to some of our recent reports. I also included, unfortunately, we weren't able to be joined by Henderson Hill, but he did an introduction to a North Carolina organization, Center for Death Penalty Litigation's A Racist Roots Project, which ties the history of the death penalty in North Carolina to its history of racial injustice. And that's a great website. It's pretty multimedia to explore. I would also just want to make sure that when we're thinking about the present and future of the death penalty, one thing that I'm also seeing more is a connection of this death penalty conversation to broader conversations about the criminal legal system, racial injustice, and what kind of role we can play as the public. The Death Penalty Information Center doesn't take a specific position on the death penalty, but what we say is we want to provide people the information and analysis that they need to make their own decisions. And what we're seeing is that people are really tying in the focus on police violence and the effect that has on communities of color, the issues around mass incarceration and how we are a world leader in the people that are in our prisons, and connecting that to the death penalty, where we have this very extreme punishment, our most extreme punishment possible, that we see continually being applied in a way that does not really kind of show equal justice being pursued. So those connections, I think, are going to be more and more important. And we saw that in Virginia when they were having their discussions about abolition, how that tying in about what does it mean to value Black lives, what does it mean to actually pursue racial justice, and what is the role of kind of the public and the government in that pursuit. We've also seen this with a lot of these prosecutor campaigns, where so much of what happens in the criminal legal system happens on the local level. When we talk about the death penalty, we're really talking about the death penalties in the states where it's being applied, because there are different rules, different laws that apply. So when we're looking at that, the death penalty particularly, there's so much about it that is determined on the local level, and where this conversation has really come up is the election of prosecutors. So what I think we can look forward to in the future is a discussion about these issues that really sees the criminal legal system holistically and sees prioritizes some of these life or death decisions as places to really address some injustices, and that also focuses on kind of the goals as far as kind of local community safety and what actually addresses and creates healthy communities.
I also have a final follow-up question for Judge Kennan. This is regarding, well, first off, I'd like to say thank you for personalizing some of the recent history involving the death penalty and representing people who are sentenced to the death penalty. And that's one of the things, or one of the anecdotes that I really enjoyed that was a part of your Pursuing the Horizons recent book, Stories of Justice. Did you want to go ahead and mention a little bit about the ideas or the circumstances that led you to this book and writing it for the audience?
Well, I wanted to share various stories of justice from both on the bench, but also on the other side of the bench. And I talk about two cases. One is the execution of John Evans in Alabama, which was a botched execution that I had to witness, where Mr. Evans was jolted 3 times with electricity, and the whole process took 14 minutes, and it was the 7th execution in this country and the first in Alabama in modern times. So it was a shocking event, which I hoped then and hope now would have some influence in the public. And then the next case, and I guess if I have 2 minutes, I would also say an anecdote to sort of support Nguzi's talk about racial justice. We had a clemency hearing before Governor Wallace, where I was with my client's sister, and it was just the 4 of us, the governor and one of his aides. And we had found out that Governor Wallace, when he was a young lawyer, had argued successfully before another governor for that individual's clemency on the death penalty. And so I mentioned that to him, and he responded that, yes, he remembered the case very well. And his argument to the governor then was, one, the state had offered him a life sentence, but the defendant was stubborn and refused to accept it and wanted to go to trial. And second, that this would be the first Black man to have killed his Black wife in that county, and that's never happened before. And those were the reasons why that governor granted that individual clemency. And then the other case I wanted to discuss is what I call Helter Skelter Son, which is, an argument and that is made for the death penalty. What do you do about individuals who commit murder and then kill someone in prison? And that was that case. And the issue is, can anyone be redeemed? Can a jury find redemption in an individual who grew up in a horrific home, who had brain damage, who had a childhood that no one on earth would ever want to have? And could that be used to redeem him in the eyes of the jury? So those are the things I thought were important to bring up, the worst of the worst, and also highlight. Also in that case, I will add, we had all the resources we wanted. The Maryland Public Defender allowed us to hire a psychiatrist, a social worker, a neurologist who was the leading studies on brain damage and violence. So Maryland at that time was putting its money in these cases where many states, quite frankly and sadly, were not.
Excellent points. Well, I personally would like to thank and future of the death penalty. It's an amazing and horrific application that we've seen sometimes in the past, and I want to thank both of you for the careful and in-depth research that you've done. I also want to thank the audience for joining us for today's presentation. As I mentioned at the beginning of today's session, this is the first in our series this year, so keep an eye out in your email for announcements for our next session for Leaders in Law. And I'd like to thank everyone for joining us today, for all the well-written and well-thought-out questions. And again, a reminder that you will be receiving the materials for today's session via email, so keep an eye out for that material as well. Thank you both, and thank you everyone for attending, and have a great afternoon, everyone.
Thank you, Nguzi. Thank you, Aaron.